And we're live.
Okay, we are live.
Great. Okay, welcome everybody to this presentation hosted by Housing Court Answers. This presentation is on lease renewals and tenant rights for many different types of housing. And our presenters today are Madeline Elizondo and Natalie Goncharov from Brooklyn Legal Services, the Tenant Rights Coalition. Natalie and Madeline, do you want to introduce yourselves and say hi?
Hi all, thank you so much for being here. My name is Madeline. I am a paralegal advocate with the Tenant Rights Coalition at Brooklyn Legal Services, and I'm here with my colleague Natalie.
Hi, thank you for coming today. My name is Natalie Gontrov. I'm a senior paralegal advocate at Brooklyn Legal Services, working with the Tenant Rights Coalition, and also want to thank everyone for being here.
Great. So the floor is yours. Please take it away.
Sweet. So, as you all know, today we're going to be covering lease renewals, and within this topic, there's a lot of subcategories depending on what kind of housing you have. And so the agenda today is we're going to start with market rate renewals. We're going to go over units that are covered by good cause eviction law. We'll talk a little bit about what that is, and then we'll also go over buildings that are not covered by good cause eviction law. We'll then talk about rent stabilized lease renewals, and then we'll move to project-based Section 8 and NYCHA, and then we'll finish with Mitchell-Lama and LIHTC. And then we'll wrap up the presentation with questions and answers. As Sarah mentioned, we're going to ask that people hold off on questions until the end of the presentation, but if something comes up, I know sometimes when you're looking at something, it's easier to remember your question, so you can just drop it in the chat. But like I said, because things kind of depend on what kind of building you're in, if you're dropping something in the chat, I ask that you make clear what kind of unit you're referencing so that we can know how to best answer the question. So to start, we just want to encourage everyone to stand your ground. As tenants, we have a lot of rights in New York City, but they only exist if you are willing and able to assert them. And so that starts with being educated on what your rights are and how to assert them. That's why Housing Court Answers is such a great resource for all tenants. And as we mentioned, we're going to be sharing the slide deck and the video on YouTube after this. And so send it around to your tenant association, send it around to your neighbors, and just make sure that we all know how to assert our rights. So to start with market rate renewals, in 2024, good cause eviction law, which I'll reference as GCE, just easier and quicker, GCE was passed, which prevents the eviction of market rate tenants without good cause. And so this law also established local rent standards, which is a limit to rent increases based on inflation in a local area. So there's this whole calculation process for how this is determined, but for right now, the current local rent standard is up to 8.79%. So any increases above this percentage amount is considered unreasonable. So the standard is determined in Albany every year. And like I said, it's based on where you're at, but you can find this information online. GCE also requires your landlord to provide notice on whether or not you're covered by this law when you're getting offered a lease, a renewal, or when they're taking you to court. So if they are offering you a lease or deciding to not renew your lease, they need to provide that notice. And we'll get into that a little bit more in a second. But generally, you'll be covered if your landlord owns more than 10 units in New York State. Not just New York City, but New York State. And so I hope that you all have heard of a tool called Who Owns What. We will be like I said, we'll be sharing the PowerPoint with links to the resources that we're referencing, but if you use Who Owns What, which is a great tool to just do building research, you can see the size of your landlord's portfolio. And that is how I recommend tenants find out whether or not they're covered. I believe JustFix also has a tool. I think it's like a little survey to help you figure out if you're covered by the law. So highly recommend that resource. And
And
then,
I was just going to say, the link that you had in your slides, I put it into the chat.
okay, awesome. Thank you.
Yeah.
And then just to get a bit more into what apartments are covered by good cause, like I said, generally speaking, if your landlord owns more than 10 units in New York State, you'll be covered. But there are some exceptions. Units with high rents, which are considered over 245% of the fair market rent. So like high-rise condos in the financial district kind of vibe. But or if you're a unit owned by a small landlord, and then which is the 10 units in New York State. And then units of no more than 10 units where the owner lives in the building. So if your owner is living in your building, then you're unfortunately not covered by good cause. Co-ops and condominiums are also exempt. Units with regulatory agreements, units where occupancy is linked to employment, units where you are subletting, and then units in hospitals, dorms, hotels, or religious facilities. So those are all exceptions to good cause eviction law. Yeah. So now to talk about rent increases. So a big part of lease renewals are making sure that your rent increase is legal and that it's following the proper procedures. And so maximum rent increases are determined by the local rent standard, as I had referenced. For rent increases over 5%, your landlord is required to give you written notice. And the amount of notice depends on how long you've lived in your apartment. So if you've been there for less than 1 year, 30 days notice is required. Between 1 and 2 years, 60 days notice is required. And then over 2 years, 90 days notice is required. You'll see these three time frames come up a couple more times when we're talking about good cause. And it's always the same. So that's just a good frame of reference when talking about notice as covered under good cause, or even when you're not covered, which you'll see in a second. For unreasonable rent increases or failure to provide proper notice, be sure to self-advocate. We're going to say that many times throughout this presentation. Self-advocating is really important. And the best way to do this to start is to write a letter. And I know a lot of people call the management office. Feel free to do that, but it's very important that you document in writing all of your self-advocacy efforts. Your request for proper notice, your request for a lease renewal, everything that you're asking for. If you talk about it on the phone, follow it up in writing. It's important that you have a paper trail of the steps you have taken, and the notice that you have given on your end to your landlord of you asserting your rights. And so, like I said, failure to provide proper notice, or if you're given an unreasonable rent increase, write a letter and cite the good cause eviction law. You can refuse to pay the unreasonable increase, and if your landlord takes you to court, raise good cause eviction law as a defense. You can also refuse to pay increases over 5% until given proper notice. And like I said, raising GCE as a defense. So also in terms beyond rent increases, renewing your lease. Like I said, good cause eviction means that your landlord has to have good cause to not renew your lease. This is a big win for tenants, meaning that you can't just be evicted because your landlord feels like it, or because it's a retaliatory eviction. So good cause generally refers to breaking lease terms or interfering with the health and safety of your neighbors. which they'll call as being a nuisance. Um, so, like I said, asserting your rights, writing a letter outlining your rights is covered by good cause eviction law, and asking for a lease and or written justification for non-renewal. So it's important that you notify them that you're covered by this law and you want to know the reason why you are not being offered a lease renewal. Um, it's important that they also, as I think I already said, notify you whether or not you're covered. If they don't notify you and you find out through Just Fix that you are covered, that's another thing to make sure to bring up. They need to give you a reason, which is either that you're breaking the lease terms or you're interfering with the health and safety of your neighbors, for not renewing your lease. And then if you are taken to housing court, be sure to raise this as a defense because the burden falls on the landlord to prove good cause for non-renewal. So if you are market rate and you're not covered by good cause, lease renewal is subject to the discretion of your landlord. However, the law entitles you to proper notice. And so if you have been in the apartment less than a year, 30 days notice is required. 1 to 2 years, 60 days notice is required. And then over 2 years, 90 days notice is required. Rent increases and terms are subject to negotiations, meaning that you do not have to accept the terms offered. And you can push back by asking for what you need. As I'm sure many of you know, this assertion of your rights is really important, but also strengthened by the existence of a tenant association and talking to your neighbors, resource sharing, figuring out what's worked for other people in terms of negotiation. So I really encourage that as well. And you should also be receiving, even if you're not covered, you should also be receiving notice for increases above 5%. And regardless of good cause, if you do not receive a lease renewal, that does not mean you have to self-evict. The landlord still has to start a holdover eviction case for lease expiration in order to see through an eviction. And that goes for any issue with housing. Today we're talking about lease renewals, but with anything, you have to go through the court process and there has to be a marshal's order to carry out an eviction legally. If that has not happened, consult a legal provider. So now we're going to talk about rent stabilized lease renewals. If you are rent stabilized, you are entitled to a lease renewal. It's very important. Make sure you know that, your family knows that, your neighbors know that. That is a very big part of being a rent stabilized tenant. And so you should receive a lease renewal within 90 to 150 days or 3 to 5 months before your current lease expires. You then have 60 days to sign and return to your landlord or a management company. And then your landlord should then sign and return to you within 30 days. Yeah, it's just important in all terms of housing to just keep good documentation, save copies of things, file things away because God forbid something happens down the line, you want to make sure that you have your leases. So if you haven't received the countersigned version back, make sure to ask. And then there's some self-advocacy you can do, which I'll talk about in a second. But don't forget about the third step, receiving it back. And then also important to note, as a rent stabilized tenant, is the terms of your first lease govern the terms of your entire tenancy. So things to look out for. We'll go through a sample rent stabilized lease renewal form in a second, but just generally, is your lease a standard DHCR lease? You can always tell because there's the emblem at the top. And then is the tenant on record correct? So your spouse has the right to be on the lease with you. Of course, you want to make sure that if you're the tenant on record, your name is on there. But also, if you have a spouse that you want to get added, you've previously asked to get added, or whatever the case may be, you want to see if they're on there as well. Um, and then the dates are important. Are the dates of your lease term correct? If your lease is ending at the end of March, does the new one begin at the beginning of April? You want to make sure that those align, and there's no issues with backdating or different things like that. And then again, big part of lease renewals are rent increases. Are the rent increases legal? Does the percentage align with the Rent Guidelines Board, also called the RGB? The RGB meets every June, and you can find the allowable increases on their website. For leases signed now through September 2026, the allowable increases will be for 1-year leases, 3%, and then 2-year leases, 4.5%. So here I have a sample for us to look at. Are you able to see the window that just came up, or is it still the PowerPoint?
Yes, we see yeah, it's a sample of a lease, yes.
Yeah, I clicked the link to pull up a PDF to make it a bit bigger. Can you see that?
Um,
I may have to stop sharing and then reshare.
Yeah, it's not that big.
Okay, let me share the. Can you see it now?
Um,
it kind of just looks, oh yes, now it looks
Okay.
like a different PDF. Thank
Okay.
you.
Yeah, so same document. I just recognized that in the PowerPoint, it is very hard to read what's happening. So here we have a rent stabilized renewal lease form. Um, as you can see, this is the emblem that I was referencing previously. This is how you can tell it's a standard DHCR renewal lease. And then we're gonna go through and just walk through what's on this form and just pointing out some things to check out when you're going through and considering whether or not to sign. So, as I mentioned, the emblem at the top, here's the date. Number one shows you when your lease will expire. And with just general advice for all of this, make sure that this matches your records and what you believe to be true. Um, and then number two, you have the 1 and 2-year lease, the rent increases. And so important to note is that you get to choose whether or not you're renewing for 1 or 2 years. Your landlord does not get to choose for you. That is a choice that you get to make. And so if you get to this form and at the bottom, you get to check off 1 or 2 year, if that's checked off for you, ask for a new lease because that is your decision to make. So column B, you have the rent that you are currently paying. And then column C includes the percentage increase. Always check to make sure that this aligns with the RGB, the Rent Guidelines Board. And then also check their math. Make sure that this a 3% increase actually amounts to $32.32, and that totals $1,000, 109.57. I checked it for this one. It does check out, but yeah, we see landlords committing fraud all the time. So make sure that the math is correct. And then columns D and E, I wouldn't worry too much about that. That's for like years in which the RGB adds a random, not random, it makes sense to them. And in addition to the allowable increase, but I was consulting some of our colleagues and they said they haven't seen that in a very long time. So if you see something listed there, I just would do your research, go online. Also, feel free to call Housing Court Answers and or 311 to consult whether this is legit or not. And then for 6, this is important to know also because some people may be receiving a preferential rent, which is basically when your landlord is charging you less than the legally collectible rent. And that can be advice on that is on a case-by-case basis. So I would say if it's your first time getting offered a preferential rent, to call and ask to consult a legal professional. Yeah, just before signing. That's always a good idea. And then 7 tells you when the new lease will start, and then when it will end in the case of a 1-year or a 2-year lease. 9 is important if you have SCREE or DREE. If you don't have either of those, then just don't worry about it. And then part B is your response. So this is where you choose whether you're taking a 1-year or a 2-year lease, and then the amount that you'll be paying. Again, like I said, just make sure everything aligns, and that the math is correct. So then you'll date, sign, and then below is where your landlord should sign before returning to you. So that is a sample rent stabilized lease renewal form. Let me just share back to the PowerPoint. Okay. So if when you're going through this process, you notice an issue with your lease, letters, like I said, are our friend. Writing a letter and or an email to your landlord is going to be very important. So you want to include why your lease is incorrect. Is it backdated? Is the rent increase improper? Did you ask them to add your spouse to the lease and they didn't? Things like that. So you're going to want to include what's wrong with it. And then you're going to request a corrected lease. Oftentimes, we'll get the landlord or the management company, whoever you're dealing with, they'll respond. Maybe they'll say, oh, whatever it may be. They may go back and forth with you. And if you are going back and forth after 2 or 3 correspondences and they're still not giving you a corrected lease, or they are just ignoring you, state your intention to file a DHCR complaint after a given deadline. So you set the deadline and tell them that if they do not send you a corrected lease, you're going to file what I have listed here. It's a really long title: complaint of owner's failure to renew lease and or failure to furnish copy of a signed lease. RA 90 is easier to say, and that's what the DHCR refers to it as. So you can tell them that you intend to file an RA 90. And advocating with the Division of Housing and Community Renewal is really important because they're in charge of enforcing the regulations around rent stabilized housing, ensuring that the landlords and the management companies are abiding by the law that regulates rent stabilized housing. And so it's very important that they know what's going on. And also, this is important leverage when asking your landlord to comply, and then also just getting redress for any issues that you have with your apartment. So that was it on rent stabilized lease renewals. I'm gonna pass it over to Natalie, who's gonna talk about project-based Section 8 and NYCHA.
Thank you, Madeline. And yeah, we see your questions in the chat. Keep dropping them. We're definitely going to have a long Q&A section in the end and can try to answer as many as possible. So thank you all. So thank you for that wonderful presentation. I'm going to talk about other types of lease renewals. First, I will start with NYCHA and project-based Section 8. So generally, NYCHA is a type of public housing, subsidized public housing. Some NYCHA buildings in New York City are being converted to public-private partnerships through what's called the RAD program. So the way lease renewals work in a lot of these subsidized public-private partnerships or public housing is it's in the form of recertifications. So tenants have to certify their household income information annually in NYCHA. And part of the recertification process is that you get a lease renewal. Tenants should be receiving notices about the need to recertify, and there are very specific rules about how those notices should go out. So please reach out to a legal service provider if you feel like you're not getting those correctly. So that is how you get a lease renewal in NYCHA, and those are your rights as far as lease renewals, as they do come with the recertification process. Another type of public and housing and sometimes private ownership partnership is project-based Section 8, which is administered through NYCHA, HPD, and CDC. With project-based Section 8, there's sorry, one second. Is this the net? Yeah, thank you. Thanks. With project-based Section 8, there's a set amount of rent that the landlord can collect for the apartment that is set by the federal government. You need to certify annually, usually with management or with the landlord. The tenant should receive documents that explain the tenant's share of the rent after you recertify, and that governs how much you should be paying, not your lease. It's not always the case that project-based Section 8 even gives you a lease renewal. A lot of times that document kind of governs what your rent amount is. And your share should not be more than 30% of your income. So if you get the share document, you're doing the math on your taxes, and you're like, this is more than 30% of your income, it's possible there needs to be an interim recertification to correct the amount. And then outside of lease renewals with project-based Section 8, if a tenant household income changes, you should ask for an interim recertification. So if your income goes up or down, you should be informing that and adjusting how much your rent share is. Especially, this is really important if your income goes down, because you're now paying more than 30%. And, the benefit of living in this type of subsidized housing is that you should only be paying 30%. So you don't want to pay more to the landlord than you have to. And then if you fail to recertify in either NYCHA or project-based Section 8 buildings, your subsidy, meaning that you paying based on your income no more than 30% towards the rent, 30% of your income towards the rent, this can lead to a termination of that subsidy, which means that you'll have to pay the full contract rent that's associated with the apartment. So that can be a lot of money. We've seen tenants whose rent share is 300, but because they didn't recertify, suddenly their rent goes up to 4,000. So you definitely want to be really careful and make sure this doesn't happen. If it is an issue with the owners mishandling recertifications, you definitely want to start your attempts in writing, meaning through email or some kind of electronic communication, even if it's a letter that you're writing to their office, just like explaining your attempts, asking for them to let you recertify, and like documenting those attempts, and also most importantly staying on top of your paperwork. So knowing when you should be recertifying, as it's an annual thing. So if you're not sure when you're supposed to be recertifying, this is go to your management and be like, do you know what month I'm supposed to be recertifying, and just make sure that you're getting those notices properly. The next is next slide, please, with the Mitchell-Lama. So the other types of housing lease renewals I'm going to talk about is for tenants who live in Mitchell-Lama buildings and what we call LIHTC building, which is low income housing tax credit. The acronym is LIHTC. So Mitchell-Lama and LIHTCs are building that are public-private partnerships, so often have a private landlord with some kind of a subsidy from the government. LIHTC programs allow landlords to get a tax break or some kind of financing assistance in exchange to offer lower rents. The LIHTC rents are set by HUD, by the federal government, so Mom Donnie can't change those. And every year they set the rent amount. I did put in the link for your reference, but you could also Google LIHTC 2025. They haven't come out with 2026 numbers, but they will soon. Usually comes out in February. We're already in March. So that's how much your rent amount is. And if you're not sure if you're a LIHTC tenant, but you live in like one of these subsidized buildings, one way to check is to see if your rent matches one of these amounts. Of course, sometimes landlords mess this up. I've seen landlords not offer the new LIHTC rent amount. They often don't give you notices. You just kind of are informed that your rent went up through a letter. So it's not like a lease renewal, although many do still issue lease renewals with the new LIHTC rent amount. Some landlords will literally just send you a letter saying your rent will went up by this amount, and suddenly you get a higher bill. They often also post notices publicly in the common area of the building about the LIHTC rent amounts. Okay, what else? In LIHTC buildings, you also have to certify your income annually with the landlord. Tenants are also often frustrated by this because you don't get the benefit of paying only 30% of your income. So you have to submit your income annually so that the landlord could maintain their tax credit or financing assistance that they received, but you don't actually get any financial benefits from that. Um, it's just a requirement that the landlord has to maintain affordability in the building. And that recertification process often includes a lease renewal. Now, because the landlord needs you to recertify, but you don't benefit, sometimes tenants don't. And here, unlike Section 8 and NYCHA, where you lose your subsidy, you lose the ability to pay only 30% of your income, in Mitchellama or a LIHTC building, if you fail to recertify, the landlord can start a housing court case against you. And the resolution of these cases hopefully don't lead to eviction, but rather a recertification process. Sometimes they mess this up and they don't do it for years, and then they come to you and it's like their fault. But at the end of the day, if they take you to court, you are going to have to find 2023 paperwork to explain what your income was in those years for you and your household members. So my best advice to avoid court and to avoid having to figure out your financing from a few years ago, don't wait for your landlord. Reach out to your landlord management directly, figure out when your recertification is supposed to happen, document your attempts to reach out to them, stay on top of your paperwork, put in your calendar, okay, I recertified last year in February, it's coming up in February, let me just throw that in my calendar, remind myself somehow that this is something that should be happening so that you don't fall behind these requirements and don't have to find paperwork from a few years ago. So there's a lot more nuances when it comes to project-based Section 8, NYCHA, Mitchellama, and LIHTC that are more individual and specific. So if I didn't name something that is an issue that you're having with lease renewals, we will try to answer in the Q&A. But generally speaking, if there's something shady going on with your lease renewals and these kind of housing, I do reach out to Housing Court Answers or 311 to ask for some housing assistance to get some advice on a renewal. And that concludes our presentation. And now we will move to the Q&A portion. And I'll let Housing Court Answers help us out with that.
Great, thank you. And we have so many great questions in the chat. I'm gonna go up to the top and just go through them piece by piece. Let's see. So going back to, all right, we're taking ourselves back to the unregulated apartments, good cause. Definitely very confusing for many, many tenants. Okay. Yeah, and so one person mentioned how good cause eviction, that law does not protect people when there's a new certificate of occupancy from after January of 2009. Just wanted to know if you guys wanted to confirm that, maybe share anything about that. Oh, you're muted?
Sorry, do you want to?
You go ahead, Nat.
Okay, thanks. I'm so sorry. I don't think we can answer that. That seems like We can we could find out after the fact and answer directly, but I'm not sure. I'm so sorry. I haven't dealt with that specific timeline that
Yeah. I mean, it is, yeah, it's frustrating. Yeah, new sort of, I just talked to a tenant the other day where, like the building she lives in was originally built in 1901, but then they demolished part and basically made a whole new building. Anyway, yeah, it could be complicated. This might be a situation where if you were being told by your landlord that you are not covered by good cause, and it's for a reason that seems that you can't understand, it might be a good idea to call our hotline and we can try to talk you through it together.
yeah.
Um, okay. Let's see. Okay, I think this might be a question about succession rights or something like that. I've stayed with my friend for 6 years at his rent-controlled apartment, and he passed away last year, um, like August 2025. I think they might be asking about, do I have succession rights? Could I get a lease in my name?
Um, I could take that one. Um, so yeah, it sounds like you're asking for about succession rights. So not answering your individual situation with your friend, and I'm sorry to hear about the passing of your friend and roommate. Generally speaking, for rent stabilized, rent controlled tenants, tenants have a right to succession, meaning that your immediate family has a right to keep your apartment at the if you pass away or leave the apartment, like you move to Florida or something like that. If it's not a death situation, they do have to give notice that they're giving up the apartment and someone else is taking over who's in their immediate family. Generally speaking, immediate family is like the traditional things that we consider like sibling, parents, grandparents, not aunt and uncle. However, if your aunt's been raising you your whole life, like a mother, you don't have a mother, that's your mother or your grandmother has been raising you. There are case law that said this that led to the rights of tenants in those non-traditional immediate family circumstances to also be able to succeed to the lease. This also applies to non-traditional marriages such as common law marriages or LGBT couples. Most recently, there was a case in New York where a polyamorous LGBT couple where two people succeeded to an apartment. So there is, so I will say probably you don't have a right to succeed as a friend, but it's not a bad idea to sit down with a legal worker and look at the circumstance and see if there's any kind of family relation there that can be, and I'm sure the case law on that will continue to change. And who knows, you could be the one who changes it. So I wouldn't, I can't advise you individually without looking at the full circumstances and asking a lot more questions, but generally speaking, it's traditional and non-traditional family it can succeed to an apartment if you pass away or leave the unit.
Thank you. And so we had a question about 60 to 90 days from the expiration of a lease or 60 to 90 days from receipt of the lease renewal. Think that might, yeah, I think that might be about rent stabilized apartments. Um, so I think this might be about when you're supposed to return the renewal lease.
60 to 90 days, I think, is the amount of time before, so your current lease expires, is coming up to set to expire soon. You're supposed to get a renewal lease within 60 to 90 days before it expires.
Yeah.
I think that answers the question. Yeah.
Yeah, and it's a contract, so you have the right to consider it. You can sign it on the very last day before it expires.
Thank you. Um, so this is a broad question. Is just there anything relevant? Well, I guess you kind of just explained rent stabilized succession um, leases. So, yeah, I guess if you have a succession lease, is there anything you should be looking out for with renewals? Or you've just basically taken over, like the lease is in your name and you're just the new tenant of record and you get all of the protections and responsibilities that come with normal lease renewals.
You answered it, Sarah.
Okay. Oh,
Yes.
well,
There you
golly.
go. Yes, it's your lease now. They can't be like, oh, well, you're a new successor, so that's 20%. First of all, it doesn't even exist anymore, a vacancy lease renewal, but we have seen it here and there. But yes, just you get the lease and the same rent amount as they were paying. Usually what happens is either the person passed away, the contract is dead, they give you a new lease, or they wait till that lease expires and they give you a renewal, but in your name this time.
Okay. Yeah. Um, because sorry, and I'm interjecting my own question. Because let's say, God forbid, the prime tenant passes away and you're just in the middle of a lease. Um, what's the kind of timing that you would usually recommend to a person to reach out to the landlord to start having that conversation about, um, the fact that the prime tenant has passed away, you are the successor tenant. Um, when do you think a tenant should start talking to the landlord about that?
I would
Um,
say as soon as possible. Yeah, because you don't want to have any delays and then that give rise to un unwarranted suspicion or any accusations on the landlord's part. So, just being transparent about it, and knowing your rights as a successor, uh, because a lot of tenants don't realize that they have succession rights, and so they will delay, or sign leases in other people's names, and that can lead to a really sticky situation. So, I would say as soon as possible.
And then with the normal, I mean, and again, you don't want to be speculating about hypotheticals, but um, is the tenant, the successor tenant, are they like, do they get the lease? Ideally, do they get the lease in their name when the current lease expires and when it's renewal time? Or would they be getting a new lease kind of midway through the existing lease?
it depends is the answer. It's up to the
Okay.
landlord, because technically it's a contract. The person passed away. So let's say you're not paying rent, you can take the person who passed away to court, right? Obviously, there's ways to name Jane Doe and add them to a court case, but the point is the contract this can't exist if the person passed. So the landlord could offer you an interim lease, yeah, in the middle of that last one. But we've also seen them saying, when the lease expires, we'll send it to you in your name. I would just make sure that if that's something you need, that you do so in writing. So, like, yeah, it's not urgent, but just like send them a letter with, if it's, your mother's apartment with your birth certificate, showing your mom's your mom. That's a really easy example. Obviously, if it's more complicated and you don't have evidence, it's best to just kind of just explain that. Um, yeah, and if you have like if it's not a straightforward traditional family succession question, reach out to a legal service provider or call Housing Court Answers to get some one-on-one advice on that.
Great. More unstabilized questions. What happens if you lost your first, because you had mentioned how the lease renewals keep all of the, rights that came with your first one. What if you lost your first lease as a rent stabilized tenant? HCR said that they do not keep copies of leases for apartments.
That's a good question. Um, I've been told that there's not a ton that can be done unless you're going to trial and you could subpoena those records. But Nat, do you know of any?
Yeah, that's about it. I mean, generally speaking, I recommend keeping all your first leases as rent stabilized tenants because it governs your tenancy. It's the landlord's burden to keep it, but they also don't have to keep it after a certain time period. So their burden isn't that strong if it's been like 25 years. But if neither of you know, it is their, like, so for example, let's say they try to say that you have to now pay a late fee and you're like, I've never had a late fee. That's a new term. they can't add that term to your new lease. And your first lease never had late fees, so that you don't have to sign a new lease with a late fee agreement. So it, and if they take you to court or filing something with DHCR, it's their burden to show that that term is in your first lease, not yours. So if they don't have the lease, it's on them. If you don't remember it being a term that you ever agreed to and they can't prove that it's something you agreed to, I wouldn't admit that you've agreed to it and just assume that your rights are the same as when you first moved in. But it is also, just to be clear, the landlords do not submit your leases to DHCR unless there's some kind of administrative proceedings. They only submit your rent amount, and DHCR just takes their word for it. They don't have a file of your leases. The landlord's supposed to.
Very interesting. Thank you. Um, oh, okay. Definitely have heard this question before and love to hear. So what happens if your rent stabilized lease is not in that standard format that you showed? What if it doesn't have the emblem or it just looks different than a typical rent stabilized lease?
I would say ask for one that is. Um, it's possible, I mean, we can't know for sure what they're trying to do with that, but it's possible that they don't want you to know that you're rent stabilized, and don't want you to know your rights under rent stabilization law. I would just ask. Also very important that you order your rent history, to just verify your status as a rent stabilized tenant. But yeah, I mean, if they're following the RGB's guidelines for allowable increases, like I would say that that's very important, maybe the most important. And if the issue is just that they don't have the emblem, it's kind of up to you on whether that's something you want to advocate for. But they're supposed to give you the standardized form.
Hmm.
Yeah, I would add, it's not like a hill I would die on, but
Yeah.
it also opens up the landlord's ability to write their own terms that may not conform to the rent stabilization code. So I would definitely call Housing Court Answers or 311 and sit down with like a housing advocate so that you can review whether the lease terms in there are appropriate for a rent stabilized lease. But we see that often, and it's okay if it makes sense and there's nothing weird in there. I mean, you can sign it, but that's why you have those 60 to 90 days, because you're signing a contract. You should have a right to consult with somebody about it.
Oh, that's why we get that extra time to actually read them. Okay.
Yeah,
Oh
so
my
don't
gosh.
ever, that's why, like, when your landlord's like, oh my God, your lease is up. Oh, sorry, it was, March 1st. I'm sorry, I know it's March 6th. Can you sign it right now? No, I can't. This lease is gonna start in 60 days now. Thank you for your offer. Please draft one that starts in 60 days. You have a right to those 60 days and your lease won't go up until then.
Yeah, that's actually, I hadn't seen this question in the chat, but it's something that we get all the time, all the time. Yeah, and we just want to put it on the record here. So if your landlord sends you a lease, either not in the time frame that they're legally supposed to, or like they waited too long, or if they're trying to force you to sign a backdated lease, um, do you have to sign that?
No, no.
Yeah.
They may try to take you to court, but if
Yeah.
you're prepared to explain to assert your rights, yeah, they can't do that.
And you could also file a DHCR complaint, which I recommend. Like, it depends. It depends what you want to stand your ground on. If you have a good relationship with your landlord and he brought you the lease a month before, you're like, all right, fine, whatever. But you could be like, oh, that's 2 months. My rent doesn't go up, sir. And I'm gonna put that in writing. Thank you for your lease offer on March 6th. Unfortunately, that's not 60 days offer. I know I have a right to it. Here's a fact sheet from DHCR that confirms my rights. Please send a lease renewal, in the future with enough time, but I also need one that starts in 2 months from now. If I don't receive this from you, I will, seek legal means to address this. And then you could use that letter that hopefully you sent certified, that I kept a copy of, to file a lease complaint with DHCR, and then your lease doesn't get renewed for 2 years until your landlord decides to give you those 60 days, which means your rent doesn't go up. And it's true, they can't sue you during that time, but if they're suing you when you have a lease complaint with DHCR, then they have to explain why they're choosing venues, because you can't sue someone like, then the judge, it becomes a complicated situation where it's like, I am already addressing this with an administrative agency judge, but the landlord's now suing me about it, which is kind of like venue shopping,
Mm,
so yeah, if you're like tired of the nonsense renewals and you feel like your rights are being disrespected, stand your ground and file a complaint. Send a letter, make sure it's in writing.
yeah, thank
And
you.
and don't be afraid of the lawsuit too much. I know it's scary, but and it's annoying to go to housing court. Don't get me wrong, it's not the most fun place to be, probably the worst place to be. But at the end of the day, if you're a rent stabilized tenant, you have a right to a lease renewal. So if your landlord takes you to court and the reason for the lawsuit is because you haven't signed a lease renewal, the resolution to that case is signing a lease renewal.
Yeah, thank you so much. Um, so the Rent Guidelines Board, does the RGB provide any indication of what the next year's 1 year lease guideline will be? In order to help us tenants evaluate whether it is smart to do a 1 year lease now, followed by a second 1 year rather than a 2 year lease now? Do they ever sort of tell us in advance what they're planning on doing the next year?
No, they don't, unfortunately. And I've gotten questions about, tenants asking for advice on whether they should sign 1 or 2 years. It's really up to you, and what makes sense for you and how you. I think it can be rationalized either way. So it is really just a personal decision. But I wish they told us. Yeah.
Yeah, and one insight just to add to what Madeline's saying is the Rent Guidelines Board is a 9-member panel that the mayor elects. So when you have a very tenant-friendly mayor, that mean and he sorry, I shouldn't say he, they could be she one day, with they get to appoint the people on the panel. So you can look up who's on the panel. First of all, I recommend not asking a legal worker, but linking up with the tenant rights movement. Organizations like Met Council and others, they have yearly efforts to influence the Rent Guidelines Board votes and influence who's on the Rent Guidelines Board, right? So when you have a mayor that puts tenant-friendly advocates on the board who get to make that decision, you get more tenant-friendly percentages, right? Like if we think about the years of de Blasio, right? Like he was more of a tenant-friendly landlord. Whatever you want to think about de Blasio, I'm not saying he's a great mayor. I'm just saying because he put more tenant-friendly people on the board, we had lower percentages. Whereas the years of Adams, a landlord-friendly mayor, and Bloomberg, a landlord-friendly mayor and a landlord himself, right? We had really high percentages, like 8 or 9%. Those were some crazy years. So it really, you could also, you may not, there's no guarantee, but you can't fight to have with the rest of the tenant movement to have those percentages lower, and you should. It's really important that tenants testify and attend those hearings. And you can tell by like who's on the board. You could sometimes make some semblance of predictions about, but yeah, there's no guarantee. So it really is still your choice.
I'm just a naturally optimistic person, so I always pick one because I always believe it's going to be better the next year. Okay. Let's see. Oh, so going back to when you are planning to when you have that conversation with the landlord about the lease renewal, the rent stabilized lease renewal, and you mentioned 2 to 3 correspondences and then say, I intend to file an RA 90. Um, are you legally obligated to say that to the landlord before doing it, or is it just you being considerate, or is there just some other reason why you would want to announce to the landlord you plan on doing this?
We put that there because it can be leverage. Because essentially you're trying to get them to follow the law first, but to do what you want them to do. And so it can be helpful to say, okay, if this issue isn't resolved by March 30th, I'm gonna have no choice but to file an RA90. If you don't want to say that, you don't have to. If you, yeah, for a variety of reasons, you may not feel comfortable saying that, but it can help apply pressure and let the landlord know that you're aware of your rights, you're aware of the different avenues that you have to assert them. So, yeah, that's why we had that suggestion there. And it's all, subject to your own discretion and how things are going. Everyone has a different relationship with their landlord. And I've helped tenants who the negotiations are going really well and they don't want to bring that up until maybe 4 or 5 correspondences for whatever matter. And so when you're going back and forth, I'd say just use your own discretion on when you want to make, I guess, like a threat, if that's what you want to call it. But you're entitled to do that. So yeah.
And I think we have a related question. So if you do a lease renewal complaint with DHCR, about how long does it take for them to address your complaint? Do you have a sense of how long it might take?
I wish I could tell you, DHCR tends to move pretty slow. Um, and something else I will say on the note of advocating with DHCR, they have very specific procedural requirements for how to file things, like what to include. In certain kinds of complaints, they'll have you attach multiple copies of things. There will be different deadlines. Just pay a lot of attention to the filing instructions, the documents they're asking you to provide. Keep an eye on your mailbox. Yeah, because they can be um, pretty particular about what they want and the deadlines and things like that. Um, but at the same time, are a pretty slow agency. So yeah, there's that.
Yeah,
Um,
it's really unpredictable. The last one I did was in 2019 or 18, and I think I got a decision. The landlord never even responded, and I did a very similar one, same landlord, different building, same facts, pretty much for the most part. And one was decided in 2022, and I kid you not, the second one is still pending. And every time I request the records of what's going on with the case, the landlord still hasn't responded. I think I had to figure out how to force the agency to make a decision because I'm like, did you guys lose the case? Like, what is happening here? Like, so DHCR does tend to move slow. But honestly, a lot of times, like Madeline said, it's leverage. So you put them on notice that now they're gonna have a legal thing. They're an LLC. They might have to hire a lawyer. This is gonna cost them money. Like they're better off just giving you those 60 days you needed. Right? And a lot of times these things are resolved and DHCR is still making their decision. In fact, they often, at the end of making a decision in a DHCR lease complaint, they'll send you a request for information being like, has this situation changed? Or is there any updates? And you're like, I signed the lease 2 years ago. Where you guys been? That's a common thing.
Fascinating.
Hmm.
Um, is a lease renewal legal if it doesn't contain the lease rider and the ETPA standard lease addenda for rent stabilized tenants in each rent lease renewal?
Nat, do you want to take that one?
Yeah, sure. Technically, no, yeah, they need to have like, if they're doing any apartment individual increases, if it rent stabilized leases, if you're not getting that, that's also subject to a complaint. But mostly it's like if there's no increases in your apartment that are individual apartment improvements, like it's not a big deal if they didn't include it, but you want them to follow the law, you want to be a stickler, that's not a hill I would die on, but it is something that's required of them. We haven't seen too many landlords not offering those. And then there's other lawful requirements. I'm so sorry I don't like know all of them, like about lead information in your apartment. They're supposed to notify you. There's supposed to be a notice if there's been lead in your unit. They're supposed to ask you if you need window guards, if there's children under 6, and they're supposed to ask you that annually in case there are new people living in the unit or new children have been born. So there's like different health and safety requirements for lease renewals for all New York City tenants in general.
Oh, and also, I guess you would be just one more, because sometimes these lease documents can be so, I guess now you would also need to be getting the good cause eviction notice in that already giant packet.
Yep.
Yeah,
Yeah.
Just reminding us all that it's a contract.
yeah, yeah. Um, yeah, all those, I'll need definitely 60 days to read the whole thing. Okay. Can the landlord charge me a late fee? I don't know if it's a late fee for being late with your signing your lease renewal, or maybe if you just want to share how late fees fit into lease renewals.
It depends on what kind of housing you're in. Um, because like Nat said earlier, if you're rent stabilized and if that's not a term in your first lease, then they can't. Because that would be considered changing the terms of your tenancy, which they can't do. But then like market rate, if it's in your lease, it really just depends on if it's in your lease. Yeah.
I mean, I guess that if they put something bonkers in there, like if you are late with your rent, you owe us an extra $500, which is beyond the state limit, I imagine that wouldn't be enforceable, right?
I would imagine that would be classified as like a rent increase. Like if it's that much of an increase, I'm not for sure, but yeah, I can't imagine something like that being legal. Nat, have you
Okay.
had experience with a $500 late fee?
Yeah, that's just unreasonable. I mean, again, I would want to know what type of housing, rent stabilized. No, no, sir. I think there are limits for rent stabilization. It's in the fact sheet. I think it can't be more than $50. I'm just going off memory, but it's in the lease renewal fact sheet that I hope we referenced. Yeah. And then for other types, definitely depends. But if you're living in an unregulated, apartment, in Manhattan where you're paying $10,000 for your rent, 500 late fee isn't that crazy.
Well, I, because
You might have signed to agree to that at your first lease renewal.
yeah, well, I mean, I remember in 2019 when they said that late fees were going to be capped at what, like 5% of
For
the
rent
monthly rent,
stabilized
or
tenants. Yeah,
was it just for rent stable?
I thought
Anyway,
so. Yeah.
we're
Either way,
actually
if you have questions, just reach out to like housing court answers, have someone take a look at if it's like an exorbitant amount.
we're actually hoping to do a presentation on just fees in general.
It's a really good one. Yeah.
Yeah, Nipa had the idea for that topic. Okay. Ooh, okay. How should a lease renewal be served or delivered? Would it be certified mail? I've had one emailed to me. Was that okay? What proof can you ask in court to prove legally serving it correctly or proving failure to serve it correctly?
It's a good question. I think there, at least for rent stabilized, you're supposed to get a paper copy. I can't speak to unregulated. I know a lot of people get them uh, virtually via email. Um, and then I'm not sure about the project-based Section 8 or Mitchell-Lama, but everyone that I have assisted has a paper copy, and I think that generally that's important to have. Uh, in terms of proving that service was done improperly in court, I'm not sure.
Yeah, I don't think it's the same. I think you're serving someone a petition for court, that's what you're talking about. When you're talking about, you're not serving someone a lease renewal, you're giving them an offer of a contract. It's a little different. So I just don't want to confuse those concepts, but yeah, no, Madeline, you're exactly on point. There are rules about rent stabilization, as far as giving people a paper notice. So the landlord can't just choose to start emailing it to you. They actually have to give you a paper lease renewal, no matter how fat the packet is. However, nowadays, a lot of tenants accidentally sign a rider that says they could send you an electronic version, which is how you're getting them through an app or through an email. Most of the time is you gave up that right to a paper copy. So I would recommend never give up that right to a paper copy, because you never know what email you'll miss next month. But you'll surely open your mailbox, right? Eventually. So
Yeah,
Mm.
I have made a boo-boo with that. Um, so I taking a break from rent stabilized, I'd put a question in the chat myself. So with NYCHA and subsidized tenants, we get so many callers to housing court answers who are complaining that their management company is refusing to do the recertification and renewal process. And the tenant is hoping to avoid getting sucked into housing court to try to address something that, they've been trying to get the landlord to do it. And, if this were a rent stabilized apartment, you can make your complaint to DHCR. But if you're in NYCHA or in some other subsidized type of housing, are there authorities that a tenant can reach out to if management is failing to do the recertification and renewal, or does a tenant in that situation just kind of have to do their best to document their conversations and just expect to be dragged into housing court?
So just to reiterate, for project-based Section 8 and NYCHA, if the landlord isn't letting you recertify, you could lose your subsidy. That's some financial loss. You could be responsible for the full contract rent they created for this unit with the federal government. With Mitchell-Lama and LIHTC, you could be pulled into court. So that's the worry there. Yes, document, reach out. What I also get a lot of these calls. If you're going to the management office, that's traditionally how you communicate with the manager. And Sarah is the manager. You're like, hi, Sarah. And they're like, oh, yeah, we'll email you next week. We're so sorry. We're not taking appointments today. You never get an email. You never get notices. You're like, this ain't gonna, nope. You come back, you're like, Sarah, I'm sorry, what is your email, Sarah? You take her email and you write her an email. And Sarah doesn't respond. You come back, hi, Sarah, who's your supervisor? And you go above their head. And unfortunately, you kind of have to be a squeaky wheel. But the main thing is not to wait. Like, if you know it has to happen in February, like, don't wait to April to start that process. But it's true, we have seen negligent landlords then take the person to court in order to resolve, because they want to basically fix how much they're getting from the subsidy, and they want to it's for their own tax break, or whatever they're getting, and they need a court process in order to resolve that, which pulls a tenant to into court. But of course, the resolution of that is that you then recertify and sign new leases. I would also say, if the landlord's like refusing, just hold on to your paperwork. Like, don't throw out your 2024 taxes because you're like, well, they didn't ask for it. Now I don't have to give it to them. You will need to give it to them at some point, one way or another. Unless they're losing, their tax break for the building, because they could lose that if you're in certain types of building, or you could lose your subsidy.
Oh, that's such a good reminder about holding on to all of your own financial records. Yeah. Um, okay. And all right, so coming back to rent stabilization questions. So can a lease renewal be given to me, the daughter, as a succession lease if I haven't lived there recently?
No. Unfortunately, you have to be in the apartment cohabitating with the tenant on record for 2 years. I think it's 1 year if you are above a certain age. Um,
Disabled, if you're disabled.
okay, okay. But yeah, you have to be living together for at least 2 years and have documentation to prove that. So like primary residence, not just staying there every so often, but getting mail there, um, getting official documents, tax returns, things like that, for at least 2 years prior to the tenant on record either vacating or surrendering the apartment.
Yeah, I'll just
Um,
lift
oh no,
because
sorry, go
I
ahead.
like to remind people that succession is a type of inheritance of affordable housing. So if you're living with your mom, make sure you're doing your taxes at your mom's address. Don't be sending it to your boyfriend's house. That's not helping anybody. But we've seen some really sad situations where people get no documents in their residence because they have like a PO box or other things, but don't do that. Make sure your taxes, like official records, your government documents are going to this.
Yeah.
Also, this is the one that trips up everybody. Your car insurance cannot be in Jersey.
Good one. Although it might be, but maybe your social security is in your apartment. Like you don't need every single document, but the main ones. Like if you're going to school in Jersey, that's that. If you end up in court, like if the landlord denies you succession and they are like, we don't believe you, the super never seen you in a few years, we're gonna sue you, right? Or we just gonna sue because we want to see if you can even prove it, right? Then it ends up in court. They can go to trial, it can go to discovery. They will be able to find out that you are in school in Jersey. They will be able to find out that you own property in Florida. So, unfortunately, it's not something you can hide, but if you are living there, you gotta just keep your records. Like make sure your records are going to this address where you're living and make sure the kids know that. Like teach, the teenagers, young adults that, hey, why are you doing your taxes at your boyfriend's house? Like, what if something happens to me tomorrow? You should be able to have the right to this apartment in your name at the right I'm paying.
Yeah. Thank you. So we've got these questions are so good. So, more questions that we get a lot. Many New York City tenants have roommates, right? Or co-tenants. Young people can't always afford an apartment just on their own. So a friend and I signed a rent stabilized lease in 2024, and I moved out before the lease renewal, and my friend stayed. Do I have to notify the landlord to remove me from the lease, or is me just not signing the renewal enough?
I'll speak generally. If your name is still on the lease, if something were to happen with rent, you will be found liable for that. And so it's always a good idea to, as you're moving out, do your due diligence, ask for a new lease. If you're in the middle of a lease term, like Nat said earlier, like it kind of just depends on how the landlord will handle that. Um, but it'll be a good idea to at least try because, you don't want something happening where you're out of the apartment, but then suddenly you're receiving papers for a case in your name because you're still the tenant on record.
And this is related. I've also talked to tenants where they were afraid to tell the landlord that one of the co-tenants was moving out because the one staying behind was just nervous that the landlord was going to say, "Oh, it's not two of you in the apartment. I don't want to renew your lease." Um, is that is it possible for a landlord to deny a lease renewal to a rent stabilized tenant if one of the rent stabilized tenants or if one of the co-tenants it has moved out and is giving up their right to half the apartment?
No, they cannot do that. It is very difficult to warrant non-renewal of a lease as a rent stabilized tenant. Um, Thanks to 2019, and just the housing movement, housing justice movement in general, everything that's led up to this, rent stabilized tenants have a lot of protection against retaliatory non-renewals, just frivolous non-renewals for things like that. And so no, that wouldn't be something that you should worry about. And if they do try, then file with DHCR, seek legal help. Yeah.
Yeah. And send a letter to your landlord in writing. I, Natalie, am no longer living with Madeline. I moved out on this day. My understanding is the lease renewal. I'm no longer living here, so please remove my name. That way, in certified, you told them, I don't know why they won't take it off. There also shouldn't be deceased people in lease renewals.
Mm,
That's very improper.
yeah, thank you. Um, hmm. Let's see. If a landlord does not have copies of signed leases and the tenant says they never received a lease for the past 2 years and the last signed lease was in 2023, can the landlord send new consecutive leases for those years to sign? Or should the landlord skip those years and only issue a new lease starting from the current date, especially if the apartment was not registered with DHCR during those years? So we're assuming that this is a rent stabilized apartment. Let me know if the question makes sense.
Yeah, I think just generally, like they should be offering you a current, a lease with a current date. And if they're not, and they failed to offer you a renewal, um, for X amount of time, that's something that they need to deal with. It's not your job to offer yourself a lease renewal. It is advised that you ask for one in writing, like we had said. But if you have in writing that you asked for one and it was never answered, and then 2 years later they're offering you one backdated 2 years, that's not acceptable. So ask for one with a current date, and then if they fail to comply, then file an RA90.
Yeah, thank you. Um, let's see. Ooh, another question. So two people can both be co-tenants on a renewal or a lease when succeeding an apartment? Like could two people um get succession rights at the same time?
That's a good question. My understanding is the only people who have the right to be on the lease together are people who are married. And so if that could be kind of a sticky situation if there's like multiple siblings who could succeed to an apartment. Um, it's possible that they'll let you put both like multiple names on there, but they're not required to do that under the law. By law, they're only required to co-list spouses. And so it would be kind of your family's decision of how you want to decide who's going to be the tenant on record. Uh, if you've asked for, say, you and your sibling to be added, and they're not going to.
Yeah, sorry. I posed that question when the brought up the example of the polyamorous couple. I was just like, oh, so they both succeeded the lease.
Yeah, I think that's because under the in the eyes of the court of the judge, they view them as I don't know if they were legally married. Um, okay, but yeah, they view them as the equivalent of a spouse.
Yeah, but it's worth a try. Like, let's say your parents pass away, two siblings living there for more than 2 years prior to their death. You have two birth certificates, worth a try. But the landlord doesn't have, there's like several rights at play, so that's why it's tricky. Um, yeah.
Yeah, thank you. Um, okay, so this question, okay, I'm not sure I'm totally understanding this one. He didn't fill my name in the lease agreement and the lease ends um this April at the end of the month. And the renewal documents come, and what should I do? Oh, so if the landlord forgot to put your name in the lease agreement, should you still sign it?
No.
No. Yeah, it's not, it's a contract.
Okay. And somebody wants to renew it in their name. Okay. And
Yeah, on that point too, like don't sign something and expect them to fill it in afterwards for you. You're gonna want everything filled in and ready to go for your signature and then their counter signature um, when you're completing the lease. Like in terms of that example, like don't leave the name empty and then sign it thinking, oh, okay, if I ask them, they'll just fill it in for me and then give it back. don't expect them to do that. Make sure that everything's proper before you agree to sign.
Yeah. So
Also,
we've got another question. Oh, sorry, Nipa, were you going to say something?
yeah, I just want to point out that a lot of people like think like because they have like a great relationship with the super, they think like the super is their friend, and yeah, like the super may like you, but they are usually not the one running the place. So your super may be cool, but like management may have a totally different view of you.
Yeah.
Also, even if you know your landlord directly or have interacted with the building manager or the higher ups beyond the super and y'all have a good relationship, that could change at the drop of a hat. Not to scare you, but you just don't want to rely on anything like that. And you always want things in writing and yeah, do your due diligence because God forbid something happen, it'll just be a shame. Yeah.
Yeah. What steps can a constituent take if their adult daughter, who lives with her in the apartment, is not being added to the lease by the landlord? The daughter is 23 years old, is a student, currently doesn't work. The mother has attempted to add her to the lease, but when the new lease was returned, the landlord had scratched out the daughter's name. Both have lived in the apartment for over 10 years.
So they legally they don't have to add the daughter until the mother vacates. And so yeah, you have notified them that that's your intent, but just make sure that you keep, like Natalie said, like records getting mailed to that address, because as I previously mentioned, to be listed on the lease at the same time, they're only legally required to do that for your spouse. So, yeah, when the tenant on record vacates, or passes, then your daughter will have the right to be added to the lease.
Um, in a related thing, we sometimes get callers who say that they've been added to lease somewhere, but not in the co-tenant section. Um, the place where normally you could force them to add your spouse. So sometimes a tenant said, "Oh yeah, they added my daughter's name in, on another document." Just as another occupant of the apartment. Is there any way to force them to keep doing that? Or,
Like to force them to keep listing it elsewhere.
well, I mean, to force them to keep, the daughter's name somewhere on the lease, even if it's not in a co-tenant status.
I'm not sure.
With rent stabilized tenants, there's a form you could fill out with DHCR. I'm sorry, I'm not remembering the form that names who else lives with you. So if the landlord didn't give you, we don't often see that. It's rare that you see a rent stabilized lease where there's like another page in the contract that basically says who lives in your household. First of all, you have no obligation to fill that out if you don't feel comfortable doing so, who's in your household. But if you do, and you're trying to intentionally include like something like your daughter, who's not named as, one of the people on the lease, you can file another document with DHCR, just like naming who else is in the apartment. However, I just want to name that doesn't give you on its own succession rights. So again, if your car note's in Jersey and your house is in Florida, it's going to be an issue for succession. So you still need your taxes, your school records, your job records, your public benefit records to be going to the address where you reside.
Yeah, thank you. Um, Somebody mentioned rule doesn't apply to NYCHA section if they're doing a retro lease. Is that correct? They request you do leases in sequential order. Sorry, we're jumping back to NYCHA in section 8.
They're, they're not
Leases.
supposed to, yeah, but they do, and you got to maintain their subsidy, avoid court, or sorry, your subsidy or avoid court. So in a way, you kind of have to still sign it. Um, I'm sorry.
Mm,
We see that a lot where they're giving you backdated leases in NYCHA and Mitchellama and stuff like that, unfortunately.
yeah. Um, yeah, let's see. The landlord must give written notice to the tenant the right to renewal no more than 150 days. Okay, sorry. Um, let's see. So the lease, and I guess this is also, I'm pretty sure this is rent stabilized. So the lease has to be the same as the previous lease. I'm worried that my landlord will try to be sneaky and change terms of the lease.
What type of tenancy though is that about?
This is a rent stabilized one.
Yeah, so they can't change the terms. And if they try, then you should self-advocate by letting them know that that's not allowed or file a form with DHCR. But yeah, the form that we went over is the lease renewal form. Um, and as someone had asked before, is there a way to get your first lease again? Unfortunately, no, but yeah, cross-check your first lease, make sure the terms are still the same. And if they try to add anything, then yeah, push back.
Um, and just as a follow-up to that, is there a way to confirm what is a legal change that's now required in a renewal lease and when a landlord is trying to be sneaky?
It's hard to say without any like context or details, but I'd say if you're unsure, then seek legal advice.
Yeah.
Thank you.
Yeah, I will just say like this training, we should have said that a disclaimer in the beginning. This applies to the current law as it is today. Of course, on lease renewals, the law doesn't change that much, but we all know the example. We just been talking about good cause that it was a recent change. So who knows, there might be a law change tomorrow. So it definitely not, that's a very like it depends kind of answer. And that's definitely like if you're getting something new or you haven't thought about haven't seen before, aren't sure, yeah, you want to definitely just check to make sure by calling housing court answers or 311.
Yeah, thank you. Um, yeah, so I think you guys answered most of the um succession questions that we're going. Let me see. Um, Ooh, okay. Here's another one. So my landlord refuses to respond and hasn't issued a lease renewal. I'm in a rent stabilized. I have scree. It was originally Dree when my husband was alive, but then and before my husband passed, the landlord has continuously bumbled the rent amount. At one point, there was a preferential amount. So I've filed with DHCR but haven't heard back. Just only got a docket number. But yeah, this situation of not getting my renewal is affecting my scree because my scree renewal is coming up. Please advise next step. Um, yeah, the landlord just keeps refusing to correct the rent amounts and other details with the lease, not responding via text, email, phone. And I do know he is trying to sell this building. So yeah, do you have thoughts for this person?
I know that there's a form that you can submit with your scree renewal documentation that is for when you don't have a current lease to send in along with your supporting documentation. And it basically is just you have to provide proof that you reside in the unit, so like a utility bill or something like that. And it leaves you a space to explain what's happening. So I'd recommend filing that along with your renewal documentation.
And I'd forgotten about that option. Yeah. Um, yeah. If you decide after 60 days of having the lease renewal that you don't want to renew the lease anymore, and maybe you've lived in the apartment for more than 3 years, is the landlord still required to give you 90 days notice after you've had the lease renewal for 60 days already?
So I'm assuming this is referencing the 90 days notice for non-renewal. But if you are choosing to surrender the apartment and just not, if you're choosing to not renew your own lease, that doesn't apply. They're required to give you notice when they're the ones making that decision. If that's a decision that you are making, um, you could always try. I always just tell people to try and see what they can get. Out of asking for what would work for them or what they want. Um, but they're not required to give that to you. That applies for when they're making that decision. That makes sense?
I think so. Thank you.
Mhm.
Let's see. What if the landlord tells DHCR that your unit is no longer rent stabilized while you are still there? I saw this in my rent history.
You should get a legal professional to look at your rent history. There's a variety of different reasons why buildings come out of rent stabilization. Um, so it could be done legally, but there's also ways that they do that illegally. So it's really a case by case basis, and I'd recommend consulting a legal professional.
If you were living there the whole time, I can almost guarantee you that sounds illegal. So yeah, please have someone take a look at the details of that. That shouldn't be, if you're a rent stabilized tenant, you can't be like mid rent stabilization tenancy losing that. There's no rule in all the different types of deregulation. There's no scenario where even a J51 expires, you're still rent stabilized. The only one I could think of is a 421A expiration, but that's a more nuanced. So yeah, definitely speak to a legal worker.
Um, what if they're trying to force you to sign a digital copy of the lease instead of doing it on paper?
Depends on what kind of housing you're in. Like was said before, if you're rent stabilized and you haven't waived that right, you should be able to just sign it paper. If they're still pushing back, ask them to show you where you agreed to that. This is in the case of being rent stabilized. Um, can you show me where I agreed to that? Because otherwise I should be receiving a paper copy. That's what I would do.
All right. And here's a slightly different question. Can a landlord charge fees to tenants who have rental subsidies like FEPS, since the program pays rent biweekly instead of monthly? FEPS, for the people in the audience who don't know, FEPS is a particular rent subsidy that could be for families with children under 18 in the household who are receiving cash assistance. So this is not something that everybody can get. But yeah, if you do have some sort of program from the city that pays rent biweekly instead of monthly, can can the landlord charge fees to those tenants?
That seems
Yeah,
wrong,
yeah,
but
no, they can't. There's a contract rent based on the lease. Depends on what type of housing. It's rent stabilized. If it's, you could have a voucher if you're in like Light Tech, all kinds of housing, right? You could have a voucher. There's somewhere it says how much your rent is. If you're being charged more than that, um, that's probably some kind of fraud that we do see this often. It's really shady practice that happens. I'll even name government, the most regulated housing there is NYCHA, right? And we saw a few years ago a bunch of NYCHA directors were caught in some fraud scheme where they were, and we know this, like if you talk to people like, oh yeah, I know how to get into a NYCHA building. There's a guy you could pay $10,000 to get into it. That's literally, so if you're moving in and they're taking voucher apartments and they're trying to charge you some under the table fees, totally illegal. They cannot sue you for that. But it is unfortunately a practice that we see even in NYCHA.
Totally awful.
It is.
Yeah. So I'm seeing, okay, a lot of these questions have been answered. Um, ooh, okay, so I think we actually got through all of the questions that got answered some way somehow. So I have another question. So, now this is not rent stabilized. Um, so yeah, unregulated tenants who are trying to figure out if they are covered by good cause or not. Um, this can get especially confusing for unregulated tenants when the building is sold or foreclosed on or auctioned, and trying to figure out if they have good cause protections is very confusing. So I was wondering if you could maybe speak about this a little bit. Uh, yeah, maybe I'll just leave the question there for you to say like what your thoughts on this are.
Yeah, it can be tricky for sure. I think generally going on Acris, which shows the ownership information, and if it's being foreclosed on or if there's a sale of the building, there will be paperwork on this database, which is linked to the building's who owns what profile. It's kind of getting into the weeds here, but if you go on there, you can find the building transfer or sale information, because sometimes when things are moving like that, the owners listed on the first screen of the who owns what page for the building will not be updated for some time. And granted, sometimes the information on Acris won't be updated for quite a long time as well. Um, but it's worth a shot to see if you can see who bought the building, or what's happening with that, and then try to go from there, to see if you meet the good cause eligibility conditions. But beyond that, foreclosure is a tricky place to be in. And it kind of just depends on, yeah, what the case is with your building. Nat, did you have anything to
Yeah,
add?
the only thing I would add is if you're in a building with more 10 or more units, your good cause doesn't matter who owns it, right? Now if you're in a building that's 6 units, it depends. Like a new landlord could buy it. It's the only building they own. It's possible it's no longer subject to good cause if it had been previously, if the prior owner owned multiple such buildings. So it depends. I really like to check who owns what also for that, just because it shows you who else owns it, what other buildings your landlord owns. And the way this really shows us up is notice requirements. And then let's say you like whatever's going on with the lease, you end up in court. They have to prove in court that they are subject or not subject to good cause. And that's where it really gets litigated. And they can't just like, gaslight you and paperwork that they sent you.
Yeah, I mean, I guess I'm thinking of this because I recently saw uh, a a case where um, a bank was now the owner of a building, um, because I guess it was foreclosed on, and and when they started cases against all the tenants in, this not big building, um, they said that the tenants did not have good cause uh, because they were just licensees. Like they said, well, we're not the ones who gave you a lease to move into this unregulated apartment to start off with. And yes, now we own the building, but we're not the ones who ever gave you a lease in the past, so we don't have to continue your tenancy. You're not covered by good cause.
I mean, I'll just take this like, okay, first of all, don't ever rely on anyone telling you whether you are or aren't part of good cause. What we're saying is figure it out yourself. You're in a building with more than 10 units, you're getting that letter. That letter is wrong.
Hmm.
You are subject to good cause, meaning that a landlord, you kind of similar to rent stabilized tenants, except you don't have the same remedies, have a right to a lease renewal now. Unless they have a good reason not to renew your lease, such as a nuisance or other good reasons that I'm sure court cases will continue to establish. But if it's just like, I don't feel like it, and you live with more than 10 units, they're wrong. And I wouldn't take the word of the landlord or a bank ever.
Just good
Also,
advice in general. Yeah.
yeah, also while we're talking about good cause, calling 311 is not a reason to not renew your lease if you're covered. So,
Mhm.
yeah, should be noted.
Yeah. Yeah, that would be a bad cause to
Hmm.
not really. Yeah. Um, yeah, and so maybe this is a good moment to also point out that Good Cause we had a workshop recently on Good Cause. If you missed it, the video is on our YouTube channel. That can be helpful for folks in the audience who need to learn more about that specifically. There's also a new brochure coming out soon on Good Cause that I put the digital version into the chat. But also if you're here, you might be interested in more topics that are coming up in our workshop series. There's going to be one on atypical pathways to rent stabilization, like de facto rent regulation and horizontal multiple dwelling. Should be very exciting. There will be more topics on subsidies. There will be topics on NYCHA specifically. Topics coming up. Uh, oh yeah, yeah. Certificate of occupancy. It's the kind of thing where you might need to talk to a lawyer specifically if something has come up. Um, but yeah, I guess I want to thank our presenters for answering so many of these deep questions and also for the presentation on this topic that tenants constantly find this interesting, important. Yeah, I just really want to thank you all for being here and giving this presentation. Are there any sort of like last thoughts that you'd want to leave with the audience?
Um, Thank you for having us. Thank you for being here. Um, yeah, just always be sure to be knowledgeable of your rights, keep your neighbors informed, make sure you're talking to one another. Sharing resources and information is so, so, so important because when you're not alone, it's a lot easier to self-advocate and, yeah, find a housing justice organization to be a part of.
Yeah, great. Well,
Thank you all.
thank you. Thank you, Madeline. Thank you, Natalie. And thank you to everybody in the audience. And stay tuned to Housing Court Answers for more workshops.
Yeah, we just put up some new workshops today also. So definitely feel free to check them out. We're having a benefit access training that's in May, but we'll have new trainings up next week also. So definitely feel free to check those out. And also our HT, if you guys want to refer your tenants, because I know some of the language on the advocates workshop can be a little bit language heavy for tenants. We have the tenant workshops, which is the HT workshops, and we do those monthly. And this month we have quite a few in Spanish. So anybody who needs that, feel free to sign up.
All right. Thanks, everybody.